Hi everyone, Harry here to talk about a really important and potentially explosive development in the Mar-a-Lago case for the DOJ, not the Manhattan DA, not Fulton County. The Mar-a-Lago, which may be the first one DOJ brings and might be a third case brought overall. But we've had a really important development involving a witness named Evan Corcoran. Evan Corcoran is the lawyer for Trump who is on the scene in, I think it's June of last year, when after diddling around for months and months and months, and at which point the government discovered that Trump had all these classified documents, they sent him a subpoena. And what comes back is a few documents. We know now there were literally hundreds withheld, and a signed attestation, which you have to do in these subpoena cases, saying, I've performed a diligent search and I've gotten everything, or that's normally what you say. What happened here is Evan Corcoran drafted something that said, we've done a diligent search and we've got everything, or substantially everything, or everything we could find, etc., and turned to a younger attorney on the team, Christina Robbins, said, here, sign right here. And she had the foresight to just put in, interlineate, as the lawyers say, saying, based on the information I've received. That would be, of course, from Corcoran. Okay, so that subpoena, of course, is false. And its falsity, it almost certainly, it was knowingly false by someone, and its falsity would be a really big piece of evidence, maybe even a freestanding crime in the contemplated charges of obstructing an investigation into the recovery of classified materials. There are a few different charges in play in Mar-a-Lago, but that's the basic idea. All right, Evan Corcoran is called. Oh, Christina Rao, by the way, cooperates. She has told her story, and her story seems to be, I did what Evan told me to do. Evan Corcoran comes to the grand jury, and they say, okay, what happened? Did you have any communications with the former president? He invokes attorney-client privilege. I won't tell you about them. They're covered by attorney-client privilege, and walks away. And the Department of Justice goes to the chief judge of the D.C. District Court, Beryl Howe, who actually has just now stepped down. Her term ended. And this opinion I'm about to tell you about is her last act as the official chief judge. And they say to Howe, we want to look at this stuff, and we think the attorney-client privilege doesn't apply. Why? The good old crime fraud exception. Remember this one? Judge Carter, among others. This has been now applied to Trump a couple times, and it in and of itself is, first of all, it's really rare to do it, but it's incredibly damning. So what it means is that the Judge Howe, found that there is a likelihood, sort of a 51% chance, that the communications that Corcoran is trying to keep secret are made in furtherance of a crime. So communications between Corcoran and Trump seem to be in furtherance of a crime. And when that's the case, you can't use attorney-client privilege to shield them. She did something more, though, really unusual for a crime fraud case. She didn't just say, Corcoran, you need to show up and testify because there's no attorney-client privilege. She ordered him also to produce evidence, documentary evidence. So there are emails and notes and personal transcriptions. Let me get this exactly right. Transcriptions of personal audio recordings. Stop and think about that for a second. So I'm not sure there's more than one way to read it. Certainly the obvious, natural way to read it is he made audio recordings, personal audio recordings. That suggests that he did it on his own, like Michael Cohen did once upon a time, like Brad Raffensperger in Georgia did. Do you maybe sense a pattern here about people not trusting Trump and wanting to make tapes? So there are apparently there are apparently tapes that he made transcriptions of. I'm not sure about the tapes themselves, but transcriptions of personal tapes. That would be conversations with Trump. And if I read personal right, that means Trump doesn't know he's being taped. Think about this for a second. Evan Corcoran, unless for some reason he decided not even to tell Trump and so be such a loyalist that he basically goes on a suicide mission and orders a subordinate to file a false declaration, did this after talking with Trump. And the likelihood here is that it makes manifest that Trump knows what's happening, and there's just nothing like transcribed audio unless it's the audio itself. So this is all a little speculative. Actually, let me bring you up to date. So Trump, as expected, files an appeal yesterday, and this is truly extraordinary. The Court of Appeals says, okay, you've lodged this appeal and asked us to stay everything. We'll stay it for 24 hours or so. And they issued an order that the that Trump file a brief by midnight on Monday last night, and that the Department of Justice work all night and file theirs at 6 a.m., which they did. So that really suggests they are not putting up with any kind of Trump delay foolishness. And it further suggests they are going to be ruling probably today on the motion to stay the ruling of the district court below. Trump, of course, can then try his luck at the Supreme Court, but this is not there's not a big legal issue here of the sort the court would expect to be interested in. So if the Court of Appeals denies his motion, then I think the Supreme Court will pretty quickly maybe grant a quick housekeeping stay, but then turn it down. And then Evan Corcoran back to the grand jury to fess up and also to provide this documentary evidence that, to my mind, has the possibility of being a smoking gun that makes Trump's guilt for the Mar-a-Lago obstruction almost indisputable. So this could be on the order of, the 18.5-minute gap, the missing tape that brings Nixon down. It's this case that is farthest along in the Department of Justice, and this sort of evidence could be just total killer stuff of Trump's intent, really undeniable. So big things going on in Mar-a-Lago, even as all eyes are on Manhattan, or maybe with a sidelong peripheral glance to Georgia. But it's Mar-a-Lago that really could be producing a killer case against the former president based on the failure to produce the knowing obstruction of a search for classified documents. So stay tuned. Once the Court of Appeals rules, if it rules against Trump, we're really on a roller coaster downhill to quick Corcoran testimony. We won't know it at the time. The reason all of this is secret, it's still in a grand jury. But what we will know is that the evidence, whatever it is, has been delivered to a grand jury. That'll be very big news in and of itself. So stay tuned. Could be big, as in really big. I'll be following it super closely. Till then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.